Hello, everyone. Welcome to today's COVID-19 Employer Guidance webinar on how to navigate the most common challenges. My name is Rebecca Wenglinski. I'm the Director of Marketing and Business Development for Kerr Russell. Before we go ahead and get started, I just want to walk through a couple housekeeping items. You do have a questions area on your GoToMeeting toolbox. So if you have any questions throughout the presentation, please submit those. I will be checking them throughout, and we will be making some time at the end here for a little bit of Q&A. We are going to do our best to keep within the hour time frame to be cognizant of everyone's time, but knowing that we may run over a few minutes. So with that, I'm going to turn it over now to Doug Belot, who is President of Qualified Staffing. Doug? Oh, I don't know what just happened. Just one second here. Doug, are you still there?
Yes.
All right, Doug, if you would like to go ahead and say some opening remarks, that would be great.
Rebecca, it sounds like we lost Doug. Why don't you make some initial remarks?
Okay, so hopefully Doug will be able to join us shortly here. So this webinar was brought together in conjunction with Qualified Staffing and Kerr Russell. So it is a group effort to try to help everyone as best as we can right now with the ever-changing policies that are coming about with COVID-19 to help the employers as best we can. So Doug, I'm going to give you another shout to see if you are available to talk now. Are you there?
Rebecca, I am here. Can you hear me?
Yes, we can now. Okay, Doug, I'm going to turn it over to you.
Yeah, I'm not sure what happened there. I got disconnected and it wouldn't let me reconnect as a presenter, but thank you, Rebecca. Also would like to thank everyone that has joined us today. We have well over 300 attendees, which is great. Certainly a lot of interest in this topic. I would also like to thank the team at Kerr Russell for partnering with us on this event and pulling things together so quickly. We started talking early this week, and they got things rolling really quickly on their end, so we appreciate that. Kerr Russell has been a trusted advisor of qualified staffing for over 20 years, and we are thankful to have them in our corner at times like this. As recently as 2 weeks ago, I don't know how many of us imagined that we would be in this position, yet here we are. Like every other challenge that we're faced with, the only option is to educate, prepare, and attack it head on, which we are all doing now. As we continue to navigate these uncharted waters, our goal is to continue to provide resources and support to our clients in any way possible. And we look forward to the day that we can all get back to business as usual. With that said, I would like to turn things over to the professionals at Kerr Russell, and I believe Mark Knoth will be taking over next. Thank you, Mark.
Thank you, Doug, and thank you, Rebecca. It's a pleasure to be here today from the comfort of my own home, unfortunately. I wanted to just say basically that it's been great also partnering with your team. We found you to be very thought-provoking in our discussions about some of the issues, the unique issues that are facing employers with this unprecedented legislation and regulatory scheme that has come so quickly down the pike. In my 27 years, I've never seen anything like this as a practicing labor and employment lawyer. Things have changed in such a short time, it's hard to believe. At our firm, Kerr Russell, we got a small army of attorneys that are coursing over all the developments in this area, all the multiple areas that we're going to cover today. So I want to thank them as well. That much being said, I kind of want to dive right into the first slide, Rebecca. I don't have the slide up on my screen here, but I assume you all can see it. This COVID-19 global pandemic, we first heard about this in December of 2019, which is hard to believe, a few short months ago. Maybe we didn't even hear of it. Maybe we didn't hear of it until, weeks or even a month after that. But since its appearance, it has spread into a worldwide global pandemic affecting just about every country on the globe. As of midnight yesterday, I checked the Johns Hopkins website, and they indicated that there are now 69,171 confirmed cases in the United States and 1,050 deaths. We're here based in Michigan, and we have well over 600 cases. Industry is pretty much shut down at this point. So in light of this, the federal government, state governments, and even some local governments, depending on your location, and I know we're talking to people from all over the country today, have taken unprecedented regulatory action, and there are so many unanswered questions for business. We're going to try to help you guys, help businesses and companies, employers, get a better handle on this myriad of regulatory morass. The items we're going to cover today, it's going to go sort of quickly, so it's going to be like drinking out of a fire hose, and we ask that you hold your questions till the end. There'll be a question and answer opportunity. We're going to cover the paid leave legislation, which includes the Emergency Paid Leave Act and the Emergency Family Medical Leave Expansion Act. Those are two separate pieces of legislation that just came out last week. We're going to talk about the WARN Act, the Worker Notification Retraining Act, which requires certain notifications, or may, in this situation, may not. We don't know yet. We're going to talk about some of the basic Osha requirements for employers that have people still working. Even though here in Michigan, many of our companies are on shutdown due to the executive order we received, we know that many other states have people working and potentially getting exposure to the virus. We're going to talk about different EEO issues, somewhat briefly, but the types of measures that a company can take and not get into the problems involved with making a medical inquiry of an employee, which can lead to a violation of the Americans with Disabilities Act. We're going to be talking about unemployment considerations. And under the Unemployment Act, every state has their own Unemployment Act, but they're pretty much dictated to by the federal government. So many of the things that happen at the state level are coming from the federal end based on funding considerations. We're going to talk about those. Some of those will be particularly Michigan. We're going to talk about what is an essential business service, where some of these executive orders have been put in place in different states. What are the circumstances under which business can continue to operate? We're going to analyze that and some of the concerns related to that. And then lastly, even though it's just barely trickled out at this point, we're going to try to talk about some of the financial benefits that may be available to businesses as we move forward in this, what looks like maybe a recession coming to get through this pandemic. So if we switch to the next slide, the legislation related to the Leave Act. This is all part of a broader piece of legislation, a very dense piece of legislation which covered many things other than employee leave, called the Family First Coronavirus Response Act. Passed last Wednesday, the 18th, set to take effect on April 1st. So we just learned April 1st when the Department of Labor issued its questions and answers yesterday. This is a bit of a curveball that was thrown to us because everybody was thinking, based on the original legislation, that it was going to be effective in 15 days. So this is a clarification. And as we move along, there are many tweaks that are happening to all these pieces of legislation. So it's a bit of a moving target for companies and, quite frankly, for lawyers. Under this legislation, certain employees will be entitled to paid leave benefits. And those leave benefits are going to eventually be reimbursed by the federal government. That's the concept. And my partner, is going to talk about that a little later as it relates to, how you get your money back and how it gets reimbursed and so forth. So the two major components are the Emergency Paid Sick Leave Act, which we'll refer to with the acronym EPSL, and the Emergency Family Medical Leave Expansion Act, which is, essentially an expansion of the provisions contained in the Family Medical Leave Act. Let's start with the Emergency Paid Sick Leave Act. Next slide, please. So what this legislation essentially provides is 80 hours of paid leave to employees. Covered businesses are extremely broad. This is legislation that didn't previously exist. Covered businesses are any private business employer with fewer than 500 employees, which is a little peculiar. Don't really understand the policy behind that larger employers don't have to pay a leave benefit. I've heard commentary say that the assumption is that larger employers are in a much better position to whether that they already provide paid leave to employees. Some small employers may be able to make a hardship argument that they're not required to participate in this mandate, and that's a company with less than 50 employees that will be exempt. Kevin Block is going to speak about that shortly. Who are the covered employees? All the employees of covered employers we just described are eligible to take the sick leave, and we'll get into a little more detail on that. Independent contractors at this point in time are not included. They're not allowed to participate in this legislation. Next slide, please. What is the benefit that people receive under the Emergency Paid Sick Leave Act? Employees who are unable to work for reasons related to COVID-19 may be entitled to receive 100% of their regular wages, so their full pay up to $511 a day. So we would assume that most people are going to get their full pay. One of the intricacies that has come out of this, does that full pay include just their base pay, or does it also include their overtime? There is some commentators out there have indicated that the number has to be computed based on the regular rate of pay and an average rate of overtime. More to follow on that, perhaps from the Department of Labor. That pay is supposed to continue for 80 hours or 2 weeks. If an employee is unable to work or telework, which is an important thing that appears throughout this legislation, because they're subject to a federal or state local quarantine order. So in Michigan, we have that. Other states do not, as I understand it. Employee gets the benefit if they've been advised by a healthcare provider, a doctor, that they got to go home and self-quarantine. That could be someone with pre-existing conditions or symptoms or something of that nature. And of course, the last factor, they get the benefit if they're experiencing symptoms. The telework aspect is interesting because if you can send a person home and they can do their job from home, they're arguably not going to receive this benefit. So that's going to be a sort of a question you're going to all face once we get into this entitlement to this benefit. Next slide, please. So there's a second tier of benefits under the Emergency Paid Sick Leave Act. It's a lesser benefit. Another group of employees will only receive 2/3 or about 66% of their normal wages. So up to $200 a day for 2 weeks if they are unable to work or telework because they're caring for someone who is quarantined or experiencing symptoms. So the real distinction here is if they're sick themselves or they're subject to a quarantine order, they're going to get the full pay. If they're taking care of somebody else who's quarantined or sick, they're only going to get part of their pay. Also, for the reduced benefit, employees are to receive the benefit of the reduced benefit if they're taking care of a child or if they're experiencing any other conditions designated as covered. And we really don't know what those are yet. That's sort of a loose end in the legislation at this point. Can we move to the next slide, please? So benefit entitlement. There are some features to the Emergency Paid Sick Leave Act. Employees can't be required to use other paid sick time in lieu of the paid leave time guaranteed under the federal legislation. So in other words, many states now, Michigan included, many states across the country are mandating paid sick time. Employers are not allowed under this Emergency Paid Sick Leave Act to require employees to take that time or burn through that time instead of taking the credit under the paid emergency sick leave. And quite frankly, it doesn't make much sense if they're going to get reimbursed by the government in the long run and their cash flow is in a good position. Now, why wouldn't you take the government benefit on this item? Employers are required to post notices of the leave, and that was something that the DOL just issued yesterday. So if you go to the Department of Labor Wage and Hour Division section on the website, they do have a copy of that posting. So if you have employees working in your workplace, either essential employees or you're an essential business, or perhaps you don't have any sort of limitation in your state, you have to have that posting up to make employees aware of their rights, and that just came out. Employers are not permitted to retaliate against individuals who take the leave. This is a common concept in all employment law. Someone doesn't exercise their legal rights, and you can't take action against them. That's a standard, thing which is included in the act. Employers are also prohibited from interfering, not just retaliating. So if an employer takes some act to interfere with a person's entitlement to the paid leave, that potentially could serve as the basis for liability. Now, this is an interesting question, and it relates to how employers are responding now before the act is effective. Are they terminating employees? Are they doing a reduction in force? Or are they putting them on furlough? It presents an interesting question as to whether or not a termination, if somehow an employee can determine that it's based upon this leave entitlement, if they terminated the employee because of their entitlement to this leave, is that going to serve as the basis for some plaintiff's lawyer or the Department of Labor to come after the business, saying that it was an interference with the employee's entitlement to the leave? I don't know, but I think the claim is a possibility out there. Part-time employees are entitled to leave at a reduced rate. It's a proportional rate. So to the extent you have part-timers out there, they are going to get the benefit. The other interesting thing is that you could hire a person tomorrow and they're going to get that benefit because there's no service requirement for entitlement to this paid leave benefit. The leave does have a sunset date. It's the end of the year, so December 31st, 2020. This benefit goes away unless for some reason Congress decides to extend it, and leave cannot be carried over or paid out on termination. So either you lose it or you use it. Next slide, please. So the second component of the leave legislation that just came down last week, and which also takes effect on April 1st, is an expansion of the Family Medical Leave Act, which is going to provide certain eligible employees, and not everybody is going to qualify for this benefit, with partially paid leave due to health emergencies based on the temporary amendment of the Family Medical Leave Act. Eligible employees under the FMLA. So normally under the FMLA, to get the benefit, you got to work for 12 months. You got to have 1,250 hours under your belt. That's all goes away for this particular benefit. Employees who have been employed for 30 calendar days are entitled to receive this. And the employees who get the benefit are those people who have to go home to take care of their children in light of school closures or the loss of a child care facility due to the COVID-19 virus. That's a relatively narrow exception. An interesting factor here, and I think we'll probably see some interesting cases come out of this. Someone's home on telework. Is it conceivable that someone who is home on telework can't telework because their kids are, troublemakers or something? Is there a possibility that someone's teleworking, but even though they're teleworking, they still have to take care of their kids and they should get the benefit. I don't know. We're going to find and hopefully get some clarification on that from the Department of Labor, but if not, we may see it from litigation going forward. Let's move to the next slide, please. Benefits paid. How are they paid under the emergency FMLA? The first 10 days of a qualified leave is unpaid. So that 10-day period is not paid. It's employees are entitled to utilize other forms of leave that are available to them, either paid leave that the company has provided, vacation, sick time, if applicable, or the emergency paid leave, which is provided for under the Act. After the first 10 days, the leave for qualified employees kicks in, and it goes as long as the situation continues. One of the interesting questions we're seeing about this, and there's been a lot of commentators speaking about it, but we don't have a certain answer about it. What about those employees that have already, at this point in the year, burned through their FMLA time? They get a 12-month allotment, and that assumes that that's an employer with more than 50 employees. Does that employee get to reload additional FMLA time? The consensus seems to be that employees are only going to be entitled to use that FMLA leave, which is remaining in their bank as a result of this emergency amendment to the FMLA. So if somebody does qualify, they go through the 10 days, they get 2/3 or 66% of their normal wage, up to $200 a day, totaling $10,000 during the period of the leave. They're assuming because of the first 2 weeks will be unpaid and that some other leave is going to fill in, that it's going to be, $10,000. So the other item is that employee health care needs to continue just like any other FMLA time off during the period of the leave. There's some indication, and I think Kevin is going to speak to that health care, if it's necessitated by the COVID-19 virus, is going to be reimbursable by the federal government as well. There are some interesting questions about reinstatement rights for someone who does take leave under the emergency FMLA. It sounds a little premature at this point because it's not even effective yet. But normally under the FMLA, you have to return somebody to their old position if they're able to work after the end of their leave, or, their 12 weeks of paid leave, unpaid leave, excuse me. This paid leave, now that the Act applies to employers with less than 50 employees, and I'm not sure I made that clear earlier, employers with less than 50 employees have this obligation under the Emergency Family Medical Leave Act. So if you had never been subject to the FMLA before, you are now subject to it under these new regulations. That's why there's an exception. There's a softer exception about, return to work for companies that have fewer than 25 employees. Next slide, please. So we've received some recent clarifications from the Department of Labor. Number one, and this should hopefully be music to your ears, there is a 30-day period after the adoption of both of the emergency paid sick leave and emergency FMLA, where the Department of Labor is not going to enforce against employers. As long as they're making a good faith attempt to comply. So they're sort of giving companies, realizing this is such a fast and furious adoption, a chance to understand and hear the Q-Temps, the qualified staffing and Kerr Russell seminar before they're penalized for violating this act. They've issued a posting, as I said before. Go and find that on the website. There's been some guidance offered for companies that have 500 employees. The question is always, at least under the FMLA and the FLSA, do you meet the statutory requirements? So sometimes there are companies that have different divisions or are separate corporate entities. We've learned that companies and divisions will be amalgamated based on the applicable tests, and there appear to be two different tests applied to the paid emergency paid leave time. and also the emergency family medical leave. Under the emergency family medical leave, there is a particular provision that says that if you are an integrated employer with another related company, that your number can be aggregated to see whether or not you reach the 500. With respect to the Paid Leave Act, and of course, if you hit 500 or more, you don't have to pay either of these paid leaves. So it's something worth looking at. The other one is under the Fair Labor Standards Act. It's basically the joint employer standard, and that's a standard that was recently released by the Department of Labor maybe a month or two prior to all this calamity and this new legislation. So that if you're close on that issue, it's worth taking a very careful look at whether or not you are an integrated employer or a joint employer. In a nutshell, to say without running the test, if there's common ownership, if there's common management, if there's some interchange of workers between the two organizations, if there is an arm's length relationship or it's contractual on the other hand, that may show separateness and that companies aren't able to amalgamate. So those are some interesting questions, and there'll be some legal gymnastics that come from making decisions as to whether or not you comply or need to apply, you qualify under that rule. So the other question was, what about companies that give, gratuitously a real rich paid leave package? Do they get some benefit for being so nice and gratuitous early on? They have to now front all this money toward this paid leave, perhaps. It's clear now that nothing runs concurrently, that if, you're obligated to pay the paid leave, you can't replace that with other paid leave you're already giving to employees. So this legislation is in addition to Paid Leave Act. Another interesting fact we got recently was that temporary employees are now counted for the 500 employee cutoff. So if you're a company that's close to 500, you need to count your temporary workers to make a determination as to whether or not you meet that cutoff. The question that is not clear is whether or not those temporary employees are to receive benefits from their actual employer, the company that hires them and place them with the customer or the company that's doing the count, or if the company that is actually using them for the count have to pay that benefit. We believe that we surmise, we don't know for a fact at this point, but we surmise that the customer company is going to be the entity that's going to be responsible for the fees, and that they're going to bill that back to the original employer or the staffing company. So the next one is, some question was asked about how do we determine what the compensation due is? What if you have an employee who has, variable levels of salary from 1 week to the next? They work a different amount of hours. You're supposed to take an average reading of the hours worked in the previous 2 weeks to come up with the number that applies for the leave amount that are going to be paid to that employee. The other item that was recently clarified that's not on this list is that overtime payments, if that was part of the prior week and in assessing a person's weekly wage, that is to be included as well. Next slide, please. I'd like to turn this over to, Kevin, is this your time?
Yeah, this is me. Yep.
Yeah, so this is Kevin Block. He's a fantastic attorney at Kerr Russell as well, and he's going to give me a chance to take a drink here. Kevin?
Right. Well, thank you, Mark. I'm going to touch on two things also related to the EPSL and the E-FMLA. The first one Mark mentioned relates to the small business exemption. And as Mark also mentioned, there was an expansion of FMLA coverage to employers with less than 50 people. So first off, we now have a universe of employers that are concerned about FMLA and these requirements. And in this legislation, they did provide an exemption. And the first, not surprisingly, is they identify those employers that have less than 50. Where it gets a little bit murky is that those employers then need to determine whether payment of these payments through the EPSL or E-FMLA would jeopardize the employer's viability. The difficulty is as these leave requirements and paid leave requirements are coming into effect is that there's not a lot of detail as to what it means to jeopardize the viability of your employer's business. But there's there is the DOL has indicated that there are going to be some regulations forthcoming and further guidance on this. In the meantime, what they've advised is to provide documents as to why payment of the EPSL and E-FMLA would jeopardize the viability of the business. What does that mean? Hard to say exactly, but from a practical standpoint, you're going to have to look at cash balances and cash projections and use of the cash, and if payment of these would jeopardize the viability of your business, then you think you may be able to take advantage of this exemption. On the other hand, as we'll learn in a minute, the credit that the employers will get by virtue of payment of these extra benefits is refundable. So it kind of cuts against the notion that paying it would impact the viability if, in fact, those payments would be refunded per the federal government, which we'll turn to next. So next slide. So we heard about, and Mark explained what the employees are entitled to receive under these new pieces of legislation mandated as a result of the COVID-19 epidemic. And so the opposite side of the coin is what credits are the employers going to receive for payment of these benefits. So the employers are going to receive dollar for dollar tax credits for both the amount of EPLSA and E-FMLA pay that is paid to the employees, together with the cost of maintaining any health care insurance for those employees as well. Now, you think, okay, I'm paying my employees these benefits. I'm going to get a credit from the IRS relative to this. How am I going to capture that credit? I still have a timing issue with payment of my people and recouping that tax credit. And so the IRS and the legislation has attempted to address that. So why don't we turn to the next slide. So as I alluded to earlier, employers are going to be entitled to offset their payroll taxes against the payments. So that lessens the burden of waiting around for the federal government to refund the amount of the payments. So that's helpful, right? But what if your payments exceed the payroll taxes? Well, they've done a couple things. One, payroll taxes have been expanded by virtue of this legislation for this purposes only, to include withholding amounts, employee share of Social Security, Medicare taxes, and so you kind of expanded the group of taxes that you can offset the payments to employees against and not pay the government and wait around for a refund. There's also an issue of what if these payroll taxes, even as expanded, don't add up to what I paid my employees? Well, this is, while it's a tax credit, it's a refundable tax credit. And the IRS has provided some details as to the fact that it is refundable. And so, you don't pay the taxes if your taxes if your payments exceed your taxes, and then B, if you still haven't recouped the amount of payments, you get to request a refund from the IRS. There's going to be further details on this. The IRS has indicated and we'll see if this bears to be true, that they would expect to refund the excess FMLA and EPSL payments that exceed the payroll taxes within 2 weeks of processing. That's what they said. We'll see if that bears true. We'll go to the next slide. So as of a few days ago, the IRS has issued a couple of news releases. You'll see in the slides, describe really just what I just said about the fact that, A, you can offset the amount of sick leave against your payroll taxes. And if, whatever the delta is, if the sick leave is less than the payroll taxes, you're still paying the delta. Or B, if the sick leave exceeds the amount of your payroll taxes, then you're going to get a refund. So those are key components from the employer side as to how they're going to recoup these extra costs that they would now incur for payment of the employees for these extra benefits. With that, I'm going to turn it back to Mark. He's going to cover a few open issues on EPSL and E-FMLA, and then we'll shift into some other key issues.
Yeah, sorry, I was muted out there. I just wanted to say that since this legislation was introduced, there's been a lot of kind of information and half information that's been out there. This payment obligation and the delayed tax credit issue is something that has caused a lot of very small employers great indigestion. People without great cash flow, it's forcing them into a do or die situation in some cases. So hopefully the federal legislation offers some relief in that regard. So that's good news. So there are some pretty serious open issues still on the Emergency Paid Leave Act and the Emergency FMLA Act. And the Department of Labor is supposed to be issuing full-blown regulations on these two acts soon. We presume before the 1st, but at this moment, nothing has come out. Well, I take that back. The notices come out. They've issued a couple of sort of glorified press releases and a couple of questions and answers. I think that if you have further interest, you should take a look at those guidances because, quite frankly, that's about all we have right now to go on because this, is an unprecedented situation to a large extent. The key issue that we've been talking about quite a bit is the difference between a furlough and a layoff. What is the difference between a furlough and a layoff? What's the difference between a furlough and a temporary layoff? I can tell you that different states may have different interpretations of that, but ultimately a furlough is the type of thing where someone is temporary off work, maybe intermittently with a certain expectation of return in a short period of time. We are seeing a lot of the states, particularly, well, not a lot, but here in Michigan, the governor, in some of her administrative releases to employers, has indicated that she wants employers to furlough workers. The question is, what does that mean? That means probably that the employee is going to be entitled to this paid leave, the emergency paid leave, as well as the emergency FMLA, because they're still employees of the company. I think the great distinction is going to be, is someone on permanent layoff and are they not coming back? And does their name no longer appear on the payroll records on April the 1st? If that's the case, I don't believe they have any claim to paid benefits, with, of course, the caveat is the employer taking the action of terminating employees so that they can avoid the obligations of the act. That's a question yet to be answered. We don't know, but we're pretty sure that something will be issued from DOL that will relate to that issue. The second open issue: do employees who've been furloughed or laid off prior to April 1 count toward the 500 employee threshold? We don't know that for sure. Again, that goes back to the same question of what's the furlough, what's the layoff, what's the temporary layoff, what's the permanent layoff. Permanent layoff, I think I know what that means. But if somebody's on layoff, let's say they're on sick leave, let's say they're on some other sort of employer-granted leave or statutory leave, I think that they have a right to be counted for the purposes of the 500 employee threshold for coverage under both of these leave acts. Kevin talked about it already. What proof is going to go out to establish the small employer exception? Do you just turn over your financials and your loan documents, or is it something much more involved than that? We expect some guidance on that, hopefully, soon. But I would definitely rely on your attorney and your financial professionals in ferreting that out. We talked already, actually, about the interference and retaliation claims. And again, I basically repeated myself. That's the bullet for those claims that could arise prior to the effective date of the act. And then we also talked about telework, where somebody's able to telework, but they're going to claim that they can't because they got to take care of their kids instead. We've already talked about it, and that's something that, is a question we need the answer to. Let's turn the page, please, to the next slide. So I wanted to talk briefly, and it kind of folds right into that permanent layoff versus furlough question. If you're making mass layoffs of employees, I'm sure many of you know that there's a worker, the WARN Act, the Worker Retraining Notification Act. I butchered that, but that's what it is. What that act basically requires is for companies to give employees 60 days notice. Companies that qualify, 60 days notice of a plant closure or a mass layoff that is going to be longer than 6 months. Clearly the termination of employees is lasting longer than 6 months because that's permanent. So let's talk about this WARN Act, and should companies be worried about WARN Act issues? Another issue that's not clear, where we're still hoping for some guidance on this, and all indications are there may be something forthcoming. So who needs to worry about this? Companies with more than 100 employees. And there's an exception for that. If you're a government contractor or a subcontractor, the cutoff is 50 employees. What is a mass layoff? It's applicable to a facility. This is all focused on facility by facility. And there's a whole line of cases that talk about, well, what's a facility? What if it's a campus? What's a facility? But basically, the facility has to have more than 50 workers at a single site who lay off 33% of the workforce, or discharge 500 or more employees at the site in a 30-day period. And there are some exceptions to that 30-day period. It can be a rolling layoff, and so it gets to be a very complicated act. It sounds so simple about notice, but whether a company qualifies or not can be a difficult question to answer. It also applies to plant closures. Shutdowns of facilities. So what are the penalties? The failure to provide required WARN notice can result in back pay, fines, and penalties. The litigation is often, rearranging the deck chairs on the Titanic, because either you have a really good defense or you have nothing. Usually you have nothing if you've made a mistake in getting notice. So the good news here is there are exceptions to the WARN Act obligations. The WARN Act says that it doesn't apply, the notice obligations don't apply to unforeseen events or natural disasters. Those are two separate and distinct exceptions. Is the COVID virus a natural disaster? I don't know the answer to that. Is it an unforeseen event? Perhaps in those states where there's been a shutdown that's ordered by the government, that from one day to the next, you're notified that you have to shut your doors. Perhaps that's unforeseen, but there are degrees here that I think companies, in all states need to be thinking about, not just Michigan, particularly those states that haven't been subject to a closure order yet. So we believe, our opinion, not a legal opinion, but my gut feeling is that these exemptions will be applicable here, but certainly this is the kind of claim that could be brought by a plaintiff's attorney or a union, often pushes the issue, insisting on WARN notice payments. So it's 60 days of full wages. So it can get a little sticky depending on the number of employees you have. So that's something we're watching closely and keeping track of. Turn the page, please. The next item are OSHA requirements. I thought this is a very important topic because OSHA really is the entity that drives safety in the workplace. And if you are an employer that has people in the workplace, you have a duty, it's called the General Duty Clause, to provide a safe workplace. And clearly having a workplace where you know there's infection or you know that somebody is infected could cause some liability under the OSHA requirements. So to maintain compliance under the General Duty Clause, we've gone through in our slides here some advice related to what needs to be done. Emphasizing hand hygiene, washing your hands, of course, social distancing. We've heard it quite a bit of it now. You should probably have a plan in place where you have procedures written in a policy as to how you're going to go about isolating people. How do you determine whether there are symptoms for screening, and just procedures related to cleaning. Those are basics. Keep in mind that right now we are allowed to make inquiries about medical conditions differently than we do in normal times because there's a pandemic, and I will be talking about that in a second. Next slide, please. So the other thing is if you have a positive case, if a worker tests positive in the workplace, and that's, I guess, everybody's nightmare. What do you do when that happens? I yesterday had a call from a very good client who in Michigan is an essential employer. They're a very important company, and they have a suspected positive case. And unfortunately, the guy that tested positive was somebody that had been all over the facility. So we've been forced to run through a whole litany of procedures to try to lock down and keep the facility from having to be shut down. I think it's fair to ask the employee, who they had contact with. If somebody tests positive, you got to get them out of there immediately. If they have had direct contact with others in his vicinity, they have to be exited from the facility immediately. In anticipation of somebody who tests positive, many employers, you see it on television where they're taking temperatures of employees, asking questions of employees, monitoring employee symptoms. Normally, from an HR perspective, you would think that would be a bad idea, but this pandemic changes things greatly. These types of procedures really only come into play in the event of a pandemic. Although having a policy in place is very important, and if you don't have one now, it might be a good idea to establish one, either before workers come back from leave or during now if you're currently working and at risk of having someone show up with infection. Of course, a positive test is just like any other worker injury. It needs to be reported on your applicable reporting forms. Next slide, please. The next issue I thought I would briefly cover because it is so important, the EEO considerations, the questions we ask people about how they're feeling and, what are their symptoms and taking their temperature and whatever else, an employer can dream up to determine whether somebody's infected. Many of those are arguably medical examinations during normal times. Those are medical inquiries. Companies can only inquire into those things in a very narrow set of circumstances. It has to be job related. The pandemic has changed all that. The EEOC has indicated that employers can ask questions, pandemic related symptoms about those. Do you have a fever? Are you coughing? Do you have shortness of breath, sore throat? And there's a whole litany of conditions that serve as the basis for possible pandemic or coronavirus exposure. We have helped employers prepare questionnaires for suspected employees to keep, questioning on track so they don't stray too far. I think that's a good policy for companies to put something like that in place. You can take temperatures right now, according to the EEOC, One thing to consider is that normal, the CDC considers normal under 100 degrees or 100.4 Fahrenheit, which I thought was a little interesting. It was news to me. Clearly you can send employees home if they demonstrate symptoms of medical coronavirus symptoms. Typically that wouldn't have been allowed. And like any other leave, it's okay to get a all clear for return to work note from the employee's doctor once the thing is resolved. There is some talk about how it might be difficult to get a person back with that kind of a requirement because doctors are so overrun and inundated with caring for people. But I, for one, as an employer, wouldn't really want to have somebody back in my workplace until I'm pretty sure that they're all clear. So that's just a quick rundown of the EEO items. I would encourage you to take a look at the EEOC website. They've got from the last pandemic, which never was, back in 2009, they issued a Pandemic Preparedness in the Workplace Act under the ADA. So if you're very interested in writing your own policy or taking a stab at it, I think that should be your guide. Next slide, please. Oh, you're there. Unemployment. So Michigan, I'm going to talk about Michigan because that's where I am. Employees can choose not to come to work if they don't feel like it. They don't have to be sick. They can just say, hey, I'm uncomfortable about coming to work. Maybe I'm high risk. Maybe I'm not high risk. Maybe I'm just watched the news too much and I'm afraid to come to work. Under Michigan law, that's okay. You're going to have to check with your specific states to see if you have a similar law. But in Michigan, we have suspended the voluntary leave disqualification factor for entitlement to unemployment benefits. So employees who do that are entitled to collect benefits. Unemployment benefits in Michigan, at least, have been extended from 20 to 26 weeks. And normally, the maximum payment's about $360. It's going to be more than that. Employers with employees on layoff due to the coronavirus. So in Michigan, we've got the order that says don't go to work. We would argue that any unemployment benefits should not be chargeable to our account. And that is one of the things that have happened. Now, just yesterday, and Kevin's going to talk more about this particular federal act because most of the legislation about unemployment comes from the federal level. They've just indicated that independent contractors and self-employed workers can now collect unemployment benefits. Normally, those folks are not entitled to it. This legislation, the new legislation, has added $600 to weekly unemployment payments for up to 4 months. That's on top of what additional payments that are out there. And an additional 13 weeks of unemployment benefits through December 31st. That's about all I have for you on the employment side. I'd like to turn it over to my partner who's going to talk about essential business service, Liam Healy. Liam?
Thank you, Mark. So as we all know, many states have issued so-called shelter-in-place orders, and essentially residents are required to stay in their homes with very limited exceptions, and businesses cannot operate if they require people to leave their homes, again, with very limited exceptions. One significant exception is the essential business services exception. States that have issued these orders generally have this in place. However, each state defines essential business services differently. Michigan, for example, on March 23rd, issued Executive Order 2020-21, which adopts this basic structure of restricting residents to their homes and limiting business operation. It does have an essential business services component or exemption available. However, the Michigan order uses different terminology and essentially frames the issue as No person or entity can operate a business if it requires people to leave their homes unless it is necessary to sustain or protect life. That's kind of the overarching requirement, aside from minimum basic operations. So what does that mean? Michigan then in turn defines workers that are necessary to sustain or protect life by adopting the definition that is in some federal guidance. Let's advance to the next slide, please. So the U.S. on March 19th, the Cybersecurity and Infrastructure Security Agency adopted a memo in response to COVID-19, and it essentially broadly defines a number of services and activities which are essential business services. However, the terminology used in that document is critical infrastructure worker. And so that is the definition that has been adopted by the executive order, i.e., a worker necessary for protection of life is the same as a critical infrastructure worker. Now, other states have also used this federal guidance, and some have adopted it wholly, others have modified it. Michigan has added some categories and essentially deemed those additional categories as fitting under this definition of critical infrastructure worker. And so there's some examples there, but as you can see, they're fairly limited. One of note is suppliers and distributors, which I'll talk about in a minute. So a critical infrastructure worker needs to either meet the requirements of that federal memo or fall into one of these categories. But again, the overarching principle here is, is this person required to sustain or protect life? Why don't we move forward one slide? So circling back to the memo, these are very broad categories in the memorandum that Michigan has adopted, and these are actually listed in the Michigan executive order. But these would also be categories that presumably would be adopted or referenced in other state orders that are utilizing this guidance. But one thing to understand is that these broad categories within the memo are supported by many very specific examples of what sorts of activities fall under these general categories. So it would be very dangerous to look at one of these broad categories and conclude, well, my business is in critical manufacturing, for example, or transportation and logistics. And the one example in the news most recently, of course, is Tesla in California did exactly that. And so care has to be used when you are sort of self-designating as a critical infrastructure worker or supporting that industry. And we'll talk a little bit more about that next. So the other issue with essential business services is that even if you fit into one of these categories, that's not all that's required for business to continue in operation. There are additional requirements under the executive order, which include what you would think, social distancing, but there are other specifics. For example, even if you're a business that is engaged in an activity that would be an essential business service under the memo or otherwise, you only can use the workers that are strictly required for whatever activity you are engaged in. So it is somewhat restrictive allowance in that sense. Also, you have to, of course, practice all of the other precautions that are to be in place, such as sanitation protocols and monitoring, symptoms of people that are present on premises or otherwise on site, and then follow the CDC guidelines. And then finally, the distributors and producers that might otherwise be involved in supporting critical infrastructure workers have to be designated, at least in Michigan. So in Michigan, there's a designation requirement. It has to be in writing. So if you're in the supply chain and you're relying on the position that you are providing support or equipment or parts for a critical worker, you need written documentation of that. And also, if you are a business that is engaged in those activities, you need to designate which of your employees are going to be utilized for that. That can be, it has to be in writing as of March 31st. It's okay to do so verbally until then. And then once that requirement takes place, you can do so electronically or post it on your website. But that is going to be documentation that is going to be very important for substantiating the position that you fall into this exemption or are supporting an exempt activity. So obviously the determination of whether your business meets that criteria and can continue to operate in the period covered by this executive order is critical. And so the last slide in my section, suggested precautions, are just a few necessities for moving forward if you are going to take the position that you may be covered. And so review applicable state guidance. It should be your state. It's not your customer's location. If you have a customer in Ohio, it's not that order that's going to dictate how you need to act, and you need to essentially get designations, even if that requirement is not applicable in the state that you're dealing with. Determine the applicable definition in your state, and then document your determination that you satisfy the essential business services requirement, and then document the protective precautions that you're taking. So you continue to operate under this exception. You need to be very careful to show that you then complied with the other requirements of the order to protect your workers in this environment. Obtain written designations. We discussed that, and be prepared to substantiate your position that you fit this category. And then we've talked about other steps you might take to further protect the business. But above all, this determination should be approached with caution, and you should seek counsel in that regard. With that,
so, Liam, before we jump on, I do want to call out that it is just after 3 o'clock right now. So we do have a little bit more information for everyone. Hopefully everyone can stay on for a few more minutes, and we will try to get to 1 or 2 questions. We've had a lot come in. Everyone will receive a recording, and we will work on getting you the slides as well. Kevin?
Thank you, Rebecca. As Mark mentioned at the beginning of our presentation, this has been a kind of a fast-moving response at a lot of different levels in governmental agencies to try and address the issues that our business employers are having, and I've highlighted a couple of those on some slides. The first, and I'll mention, there's a reference to CARES Act. What is that? It's the Coronavirus Aid and Relief and Economic Security Act. It's not law yet. At least it wasn't before I signed on. It's been passed by the Senate, and was a joint effort with the president, so it has to go through the House. And so what we're saying here as it relates to the CARE Act could change, and including something Mark had mentioned earlier relative to the additional unemployment benefits. That's part of the CARE Act, and until that's law, those additional benefits won't be in place. Before we get to the CARE Act, however, the SBA, in conjunction with individual states, was also undertaking some measures to address the economic hardships that our businesses are facing, and so there are some SBA loan programs which may ultimately be impacted by the CARES Act that involved each state seeking a economic disaster declaration, and then making federal SBA loans available to certain segment of the business world. Those loans will still be available under the Act as it's currently written. They'll provide working capital needs, and the process to apply for those loans has not yet been established, but we would expect further guidance on that soon. In addition to the disaster relief loans that were contemplated before the CARES Act has also added some SBA loan programs for small business concerns. What does that mean? It has a certain definition on the SBA. It's been somewhat modified, and so if you're 500 employees or less, you're likely going to have an opportunity to pursue these business loan programs. There's some maximum amounts that would be available, and it can cover things like payroll, including salary and wages, of course, but also the health benefits, rent, insurance, premiums, utilities, and the like. There is a forgiveness component of these loans based on maintaining employment of your employees, and then also certain other expenses that the business would incur. This is all spelled out in the slides, and feel free to revisit. And there'll be plenty more commentary coming out as the law, when it's formally approved and people get their arms around how this is going to work. Next slide. There's also going to be, under the CARES Act, it's contemplated an employee retention credit, and it, of course, applies to employers whose operations are impacted by the pandemic, and or who are suspended or has a significant increase in the receipts based on the same quarter of last year. Now it's interesting, we're kind of straddling a quarter here. We're coming up on March 31. Not sure how this is all going to be measured, but I suspect there'll be some guidance on that. The slide details how the credit, and again, it's a refundable credit, and how the mechanics of that will work. There's certain parameters based on whether you have more or less than 100 full-time employees, and then some caps in terms of how much of the credit, or what's the cap on the credit, $10,000 in compensation that are paid to the employees. So that's a lot to take in. I realize it is somewhat of a moving target. It's not law yet, but I think it's important, very important for our businesses to understand that there is some, and likely to be more, some assistance that is being put forth to help address these issues. So why don't we turn to a few questions?
Okay, thank you, gentlemen. So we've had quite a few questions come in. One of them, and some of them are similar here. So from earlier, somebody had asked if the FFCRA is effective on April 1st, but we have someone out sick for COVID-19, do we pay them under this new act?
I can respond to that. You guys can chime in if you think you have an answer or something to add to it. I think at this point we don't know for sure, but our suspicion is that they are not going to be qualified for the new benefit because they're already out on leave, but that remains to be seen. It's my understanding that some new stuff may have been posted on the website today that may cover some of those issues. Have hadn't had a chance to look at it at this point in time during the time we've been on the conference call here. Kevin, you got anything to add? Or Leah?
No, I don't, Mark.
Okay. Another one is, does a shelter-in-place order from a state or local jurisdiction qualify as a quarantine?
Anybody?
Well, sure. I mean, I'll try to. That's unclear, and it depends on what purpose you're using the definition of quarantine. So a shelter order is typically going to require you to comply, and you're effectively quarantined, and that's certainly why these orders are being issued by the states, is to slow the spread and allow the health services to operate correctly, and for all the other reasons. So I guess it sort of depends on why you're asking about quarantine. Is there another requirement somewhere that refers to that term? And so it really depends on the state and the context in which that term is used.
No, I would like to add to that. I'm looking at the legislation right now, which is all marked up. So I got to try real hard to read it. But I think that, the way that the wording comes out, it's not specifically a quarantine requirement, at least under the leave laws. It can be a public emergency, state, local, or federal that is declared by the applicable authority that sort of triggers coverage under the leave laws. So I think where there's an order in place, the leave laws certainly, if that's the basis for the question.
Okay. Some have been asking for more clarification around the less than 50 employees. Do they become exempt? Just kind of reiterating some of that stuff again.
I'm sorry, can you say it again? Just a wage and hour type question?
So it's if they have less than 50 employees, do they need to become exempt? Or what do they need to do to become exempt?
To avoid the coverage? Yeah.
Yeah, so I think the question surrounds the under 50 exemption to the EPSL payments, as well as the extended family medical leave act payments. And unfortunately, that's one of the areas that is a moving target. The DOL has indicated they're supposed to provide guidance within a matter of weeks, which oddly is after the time the act takes effect. What they have directed employers to do, if they think they fall within the under 50 and it would impact the viability of the business, is to document it in the best manner that they can. And what does that mean to me? Again, they didn't add any color to that. That's bank statements and cash flows, and I know it's all extra work on top of the work that everyone's already doing, but to try and demonstrate the fact that that it is in fact would impact the viability of your business. And as I mentioned earlier, what kind of cuts against that approach or that concept is the fact that the credit, you are to pay these folks, the credit is fully refundable. And so then it becomes a timing issue on the cash flow.
I would like to chime in for a second. I'm sorry, Kevin. Go ahead. Oh, you're done.
I wish I had a clear answer, but that's all I can offer.
Yeah, and I think there's a lot of frustration, but I mean, it's really hard to understand the incredible nature of the passage of these laws in such a short period of time. I mean, it's literally been 1 week and a day since the law was passed. And so normally it takes years to get regulations out. So, I mean, I don't fault the DOL for not issuing greater guidance. I'm sure they're going to issue something soon.
Okay, one more question here. Are suppliers and manufacturers considered exempt?
So
by that, I believe that they're meaning exempt as that they are considered essential business?
So it depends. And, the first question is, who are they supplying, and what is the underlying activity that they're involved with? And so, if they are asked to produce, then the first thing is to require a designation, at least in Michigan. Beyond that, I think that there is a requirement to consider not whether the underlying activity that you are involved with as a distributor or a supplier meets the essential business function that is required, or providing essential business services. So, it's really a question of state law and what activities are involved, and it's going to require looking at the specifics.
And Liam, is it possible that certain segments of your business could be considered essential and you could justify continuing to operate those, but maybe others you'd have a tough time justifying based on who you're supplying and what you're producing?
Well, there hasn't been any guidance there, but I think that the answer is yes, based on what we know at this point, because again, depending on what project is involved, certainly you could be protecting or maintaining critical infrastructure, and so we're waiting for more guidance on that. There is an FAQ for Michigan that addresses that in regard to the construction industry. So I would encourage anyone that's interested to look at that. And essentially, that is what the answer is to that FAQ. It depends on what the project is.
Okay, and Rebecca, I know we're running over here, but I just wanted to check with Mark on some clarification on the employee count as it relates to emergency sick leave and emergency FMLA. I think it's pretty clear based on the guidance that came out yesterday that temporary employees would count towards the overall head count, but that doesn't necessarily mean that those employers would then be responsible for the sick or FMLA pay to temporary employees, or could you speak to that a little?
Yeah, I think you could make an argument either way. Because if you're a temporary employee, depending on the nature of the relationship, you think you're employed by your staffing company and you're only placed at the client location. I don't know exactly where that's going to fall. I'm anxiously awaiting some more details on that thing. The question really is, who's going to be responsible for payment of those benefits? So I think that if you're an employing unit and, there are all sorts of nature of temporary staffing arrangements. There's contract staff and, there's direct short-termers, there's project people, so, there's a whole range. So I think it would be very difficult to answer your question just because, the nature of there's so many different arrangements. And I'm sure that the regs are going to be imprecise in defining those. I hope that helps a little bit, Doug.
Not a lot, but yes. Thank you for attempting to clarify at least.
I tried.
All right. Well, thank you everyone for attending. I know we did not get to all of the questions. There were quite a bit that were entered. We'll do our best to try to see what we can do for some posts on those matters. And please follow or go to the Kerr Russell website. And we actually have a resource page. It is a COVID-19 resource page. If you go to that, we'll try to have some more information put up there. But you do see the contact information for the 3 attorneys that spoke today on your screen. The recording and the slides will also be emailed out to everyone. And thank you again for attending.
Thank you, everyone.
Thanks, everybody.
Thank you.
Thank you.
Stay healthy.